In this section of the course, we're going to discuss criminal law. So, criminal law is an offense against the public at large. It's going to be different than a tort, which is a private wrong versus a public wrong. So, a crime, when you have a crime, a charge is going to be brought by a governmental official. I cannot sue someone and charge them with a crime. The government has to bring those type of charges. And a crime can be punishable by prison or fine. The objectives of criminal law are to punish the wrongdoer and restore order and harmony to society. And there are classes of crimes, misdemeanor and felony. A misdemeanor is typically less serious and it carries, therefore, a smaller punishment. It's punishable by prison, not exceeding 1 year, or fines, etc. And a felony is punishable by death or imprisonment exceeding 1 year. Typically, there are sentencing rules that a judge must follow in each jurisdiction. So depending on the crime that the defendant is charged and found guilty of, it'll have a range of sentencing. And the factors of that particular crime will convince the judge to either impose a very harsh sentence or a low sentence, but usually it has to be in a range of acceptable punishments. You've probably all heard of the concept of double jeopardy, that you can't be tried for the same crime twice. But what can happen is there can be different charges arising out of one action. So there could be a tort and a criminal case. The case in your book and the case that people think of most often is O.J. Simpson. There wasn't enough evidence to convict him of a crime, but he was found guilty of a tort, and he was punished by payment of fines and all of that. A crime has a higher burden of proof. So to be guilty of a crime, it has to be proved beyond a reasonable doubt that you committed the crime. But a tort has a lower standard of proof. So to be guilty of a tort, you only have to be found guilty by a preponderance of the evidence. Talking about victims' rights, the history of criminal law did not focus on victims' rights because we were focusing on crimes being a harm to the public, and so we wanted to restore order to the public. But in recent history, most legislatures have enacted statutes that afford some type of notice and protection for victims. Victims are usually notified if the person who committed the crime against them, if they are sentenced, if they are released, where they are, where they're located, where they're going to live, things like that. And the Constitution does not actually provide for the federal government enacting and enforcing criminal laws, but we have found that power. The Supreme Court has found that power in the Commerce Clause of the Constitution. The Commerce Clause allows the federal government to regulate interstate commerce, so any commerce affecting transmission across state borders. The Supreme Court found the power to enact and enforce criminal laws affecting interstate commerce here, and that is construed very broadly. So many things affect interstate commerce, even if they don't actually travel across the border. To have a crime, you have to have the act, the required mental state, and then causation. So the act has to be an action that either occurs or fails to occur. And if it's something that fails to occur, it's called a crime by omission. And to have that, usually there must be a duty. You had a duty to do something and you didn't do it, and by not doing it, you committed a crime. It cannot be involuntary actions. So if you are driving and you have a seizure and you kill someone because it causes a wreck, that's not a criminal act because it was involuntary. Now, if you have a condition where you have seizures often and your doctor has informed you that you should not drive because of that, and you still drive and cause a wreck, that could be a crime. You also have to have the required mental state. And the required mental state is one of the four. The first is purpose. You purposely did something. You intentionally intended to cause the result that actually occurred. The second is knowledge. You did something and you knew that result would probably occur. The third is recklessness. So you committed an act and disregarded the known risk of that act. And finally, negligence. You failed to see a possible negative consequence from that action. You can see these are in order from most culpable to least culpable, right? Purpose is the worst, so that's going to be your higher degree of crimes, your first degree felonies, all the way down to negligence. that might be just a misdemeanor type crime. And then finally, it has to have causation. So it could be proximate or but-for causation. So an proximate actual cause that's legally sufficient to support liability. Many actual causes may exist for an injury, but the law doesn't attach liability to all actors responsible for the causes. The likelihood of calling something a proximate cause increases as the cause becomes more direct and more necessary for the injury to occur. And the but-for causations, the tests vary by the jurisdictions, but it's generally, but for your action, this harm would not have occurred. And I think those two are pretty hard to distinguish, so I have a short video for you to watch on the causation.
We'll discuss the differences between but-for and substantial factor causation. And these are really just two types of tests that many courts use to determine whether a defendant caused damage or injury. So let's say we have a defendant here, and he takes an axe to a tree which is right next to a car. The defendant foolishly chops down the tree, damaging the plaintiff's car. Well, in our lawsuit, the plaintiff is going to have to prove that the defendant caused the damage to his car. And this is also a good example of but-for causation, meaning if the defendant had not taken the axe to the tree, let's say he just decided to make a phone call instead, the car would be just fine. The tree would not have fallen on the car. A jury is likely to conclude that but for the defendant's actions, the car would not have been damaged. For that same reason, a jury should conclude that the defendant was responsible for causing the damage to plaintiff's car. On the other hand, let's say we have a plaintiff who has a bad back, and he wants to sue his employer who he says forced him to carry these big boxes. But the plaintiff also played football, and he enjoyed lifting weights. So was the bad back caused by lifting boxes, playing football, or lifting weights? Maybe all of these factors had a role in causing the injury. So of course our employer will say, look, even if he hadn't lifted the boxes, he still would have ended up with a bad back. So we can't say that but for the boxes, he wouldn't have been injured. Therefore, the employer didn't cause the injury. The plaintiff might not be able to prove but for causation. However, he might be able to prove that lifting the boxes was a substantial factor in causing his injury. The defendant can bring evidence that lifting the boxes was at the least a substantial reason why he was injured. The court will require proof as to how lifting the boxes was a substantial factor. Looking at another example, let's say lightning causes a forest fire, and our defendant for some reason decides to throw a can of gasoline into the fire, and eventually the forest fire destroys plaintiff's house. Well, the gasoline must have contributed at least a bit to the forest fire, but even if he hadn't thrown the gasoline, the forest fire would probably have destroyed the house. In this situation, we might not have but for or substantial factor causation. The house would have burned down even if defendant didn't throw the gasoline, so we don't have but for causation. And the gasoline really didn't contribute to the forest fire, so we can't say the defendant's action was a substantial factor in causing the damage to the house. If you'd like to discuss causation or any other matter related to U.S. law, stop by my website and blog, and feel free to submit your comments below.
As you can see in this video, what we're trying to determine is if the harm that actually resulted from the action of a defendant. We're trying to determine if there is enough relationship between the action and the causation and the inevitable harm. So looking back at our elements, we know we had to have an act, a mental state, and causation. And when we're talking about corporations, generally we have trouble thinking of corporations having a required mental state. But we know corporations are legal people. They can sue, they can be sued, and they can act. So courts needed to find a way to charge corporations with crimes. And so they have done this with three different theories. First, respondent superior. And that says that a corporation is liable for the criminal acts of their employees using the doctrine of vicarious liability. So a corporation can be declared criminally responsible if one of its employees commits a crime while on the job working for the benefit of the corporation. So corporations act through their employees, and if the employee does something criminal, oftentimes the corporation will be liable. That'll be discussed in another chapter in more detail. There's also the model penal code theory. Here it says a corporation might be held criminally liable if the directors or officers of a corporation authorize, approve, or recklessly tolerate the criminal actions of their employees. Okay, and then finally the first bullet point up there, strict liability, that exempts corporations from having a mental state at all. So strict liability would find a corporation liable for a crime even without considering the mental state. And that would only come into play if the conduct was so egregious, there's no need to say they acted with a requisite mental state. In your textbook, you can read about all the different crimes and their elements. I'm not going to read it to you. I am going to focus on the business crimes because that's more relevant to our study of business law. The first is embezzlement. That's wrongfully taking property or funds that have been entrusted to the care of the offender. The important thing about embezzlement to note is that the embezzler has legal control of the funds prior to taking them. So that's why it's not theft. Theft, I go out and I take something that isn't mine and I never had legal control over that. Embezzlement means I had legal control over these funds. Maybe I work for a corporation and I was tasked with depositing cash into their bank account. And instead of depositing it, I deposited part of it and kept some. Well, I had the rightful control over that property. I just wrongfully diverted it for my own benefit. Second's forgery, falsely making or changing a writing to defraud. We think of forging a check, something like that, falsely signing a contract. The third is criminal simulation. This is similar to forgery. It's altering or falsifying art, antiques, photographs, films, tapes, recordings, and or antiquities with the intent to defraud. Passing bad checks is issuing or transferring a check or other negotiable instrument knowing it'll be dishonored and with the intent to defraud. So maybe I write checks I know are going to bounce just to get things, to get product, to get services, something like that. Defrauding creditors, that's hiding, destroying, shifting property away from the reach of creditors. And then finally, the RICO Act. It's called the Racketeer Influenced and Corporate Organizations Act. It says that conducting a legitimate business with funds acquired from a pattern of racketeering activities can give rise to criminal liability. All right, so we think of money laundering when we think of the RICO Act. So we have money that we obtain from an illegal activity, and then we use that money to conduct a legal business. That can give rise to criminal liability. Racketeering activities include a huge list of things, but some of them are mail fraud, wire fraud, arson, robbery. It can be smaller criminal type activities that give rise to a larger RICO liability. There's also cyber crimes. Again, you can read all these in your book. I'm not going to read each crime and read the definition to you. But generally, cyber crimes are crimes which are directed at computers or other devices, or where computers or other devices are used to facilitate a crime. Common types are hacking, online scams and fraud, identity theft, attacks on computer systems, and illegal or prohibited online content. If I am accused of a crime, I have defenses, right? My defenses try to negate one of the elements of a crime. So we're going to talk through some defenses. First is the defense of insanity. And I think the defense of insanity is the most misunderstood criminal defense. And there are two types of insanity. First is not competent to stand trial. So there we don't say the defendant is not guilty of the trial. They say the defendant can't even understand the charges brought against him or her, so they can't stand trial. If a defendant is found not competent to stand trial, the defendant will be sent to some sort of facility to try to render the defendant competent to stand trial. So that doesn't mean they're off the hook, so to speak. It just means the trial isn't going to happen right now, but what we're going to do is we're going to try to have the trial later after the defendant is competent. The second type of insanity is not guilty by reason of insanity. And this one is different. This one says basically the defendant couldn't have been guilty because the defendant couldn't have formed the required mental state of the crime because of some type of insanity. There are 3 tests, and whichever test applies depends on the jurisdiction, the place where the crime occurred and the trial is occurring. So the first is the Naughton rule. Under this rule, a defendant can be found not guilty by reason of insanity if at the time the crime was committed, he was suffering from a mental disease that was so serious he didn't know the nature of the act or didn't know the act was wrong. The second is the irresistible impulse rule. It says criminal defendants can be found not guilty by reason of insanity if at the time of the offense they were stricken with a mental disease that prevented them from knowing right from wrong or compelled them to commit the crime. And the American Law Institute test says if a defendant isn't responsible for a crime, if, as a result of mental disease or defect, he lacks substantial capacity either to appreciate the criminality of his conduct or conform his conduct to the law. Notice here it's just a substantial lack of capacity, not a total lack of capacity in the American Law Institute test. Some other defenses are entrapment. Here, the person using this defense would show that the crime would not have been committed had it not been for the inducement of the officer. So the defense of entrapment is not available to a defendant who would have committed the crime anyway. The factor is referred to as the propensity to commit the crime. I have a couple examples for you. So suppose a police officer threatens to harm a person, an average law-abiding citizen, unless that person delivers a package of drugs to another person, collects the payment, and brings the money back to the police. So that's clearly entrapment. This person would not have committed that crime had that person not been threatened by the police. All right, another example. A homeless man who is a petty criminal and drug addict with prior convictions for possession of small amounts of drugs and minor theft. The police suspect he sometimes sells drugs for a local drug kingpin, but it's only a hunch. An undercover officer contacts the man on the street and offers him money to pick up and deliver a shipment of drugs coming into town on a train. And the shipment isn't real. This has all been staged, of course. It's an undercover sting. The man tells the officer that he only uses but does not sell drugs. He doesn't engage in drug trafficking. The officer approaches the man every day for over a week, buys him meals, and tries to talk him into the deal. The man refuses again and again, but finally is worn down by the officers and the money that has been promised, so he does it. So this also is entrapment. Okay, the next defense is justifiable force. So you did all of these things. You committed the criminal act, but you didn't have the required mental state because of one of these things. First is self-defense. It has to be a bona fide belief that your life is in danger. Not just that your car is going to get stolen. Nothing like that. You have to believe that your life is in danger. The next is defense of others. It's just like self-defense, except you believe someone else's life is in danger. For self-defense and defense of others, usually there's a requirement to retreat. So if I think my life is in danger, but I can run away and get away without harming another person, I'm required to do that before I'm allowed to harm someone. In this third bullet point, stand your ground laws, these extend self-defense by eliminating the requirement to retreat, even outside one's home or vehicle. As long as an individual is in a place that he has a legal right to be in, then there's no retreat necessary. It depends on what state you're in, whether you have a stand your ground law. So Texas has one, not all states have one. And then finally, there's battered spouse syndrome. All right, and this is when a spouse who has been battered believes the only way to safety is to physically harm their abuser. Even if that wasn't the only way out, this is what they believe. The next category is mistake. It's a defense when it destroys an element of the crime. So you've probably all seen the news where in Dallas the the police officer got off work and went into a man's apartment and shot him, and she said she thought it was her apartment and she thought he was an intruder in her apartment. The Botham Jean case. So the police officer that shot him is arguing mistake, right? She's arguing, yes, I committed the act, but I didn't have the required mental state because of a mistake, because I thought this was my apartment. Now, mistake has to be reasonable. It has to be a reasonable belief. So the prosecutor is, of course, saying, you can say that, but that was not reasonable. You were on a different floor. This was clearly not your apartment. This is not a reasonable mistake.